Hello, all. It's a pleasure to have you back with ELTA Academy. I'm Marisa Monteiro Borsboom. I'm ELTA Academy Director and Vice President of the organization. It's a pleasure to be here today to start this new series of masterclasses that aim to bring more value to our members, and having one of our members, recent members, being one of our first trainers, Mr. Guido Ashoff, and the topic of data protection and privacy regarding legal tech. So today we will have the first of many, we hope. And with that, Mr. Guido will introduce himself. Please use the chat where Dirk Bloom, a member of Young ELTA and now assisting Academy, will support you. Please also share with us your questions in the chat. And today's session will not have a Q&A, but you can share with us your questions, and we will inform you in the next series of masterclasses that will include this time of Q&A. We will inform you about this. Please enjoy your session, and Guido, the floor is yours.
Marisa, thank you for your kind invitation of myself. My name is Guido Ashoff, and today we picked a topic from probably more the regulatory side, which is data protection in a legal tech environment. So we have chosen this topic because, from my experience with law firms, lawyers, and I'm just like doing education in that area, especially in Germany for lawyers, data protection is always kind of lacking behind. And it's probably not the most popular topic to talk about, although, with more technology coming in over the past few years, it's getting more and more important. And that's generally why we've chosen that topic. So for myself, I'm as well a DPO here in Germany, and a qualified IT lawyer handling all kinds of data protection and privacy issues for clients. And I just thought, why data protection is everybody's favorite and everybody's darling, or better saying not. And especially, for lawyers, it seems that data protection is kind of a hard one. Because if you're just like mocking a bit about the topics, you could say it definitely lacks complexity. The rules are so simple, so you can obey easily. It's a real business accelerator. And we could just like do a lot of more buzzword bingo about data protection. And today, actually, I try to share a little bit of my experience over the last, let's say, 12 years in IT law and data protection, especially when it comes to legal tech. What I forgot probably about myself, I worked for a big international publishing company back in 2006 to 2008. We could say it was probably one of the first legal techs I worked for, because we did, online training for lawyers back in 2006. And so a lot involved from that point. But I have the impression that sometimes the problems stay the same, more or less. So we're aiming today actually to try to provide you with a hands-on approach, how to tackle privacy, data protection issues in the field of legal tech. Although I really have to admit that, legal tech has so many broad applications. So it's probably sometimes a little bit broad in order to speak about privacy in this field. At certain points, we will try to get more specific when it comes to different business fields of legal tech. So, but what I find very important and what usually is lagged behind is the operational side of data privacy. So we try to give you a few of our experiences, best practices on the way how to cope with the regulations of GDPR and local privacy laws, but also how to do it in operations, in a data protection management, and how to probably, as a legal tech provider, approach clients with a good preparation when it comes to legal tech and privacy, and let's say regulatory other laws, especially from the legal side or for a law firm side. So we want to talk a little bit about mine experiences. And as I said, we want you really to show you the interplay between data protection and other regulatory requirements. So we brought some examples for Germany, but this might be quite representative in my point of view for other countries, because, as a attorney at law, or, in Germany, I would be a Rechtsanwalt, we have special requirements when it comes to secrecy with regard to our clients and outsourcing. So you don't really have not only to be aware of data protection, but also on the protection of certain information, which can, be considered personal identifiers. But, there might be different information within, this secrecy set, which you have to look at from an attorney's point of view. So that's probably, more or less the background we will talk today. So if we look at the beginning and from factual background about some simple truth, I just read the other week from a LinkedIn contact. It was more in relation to artificial intelligence and new technology, but same, let's say, thoughts apply to privacy and data protection as well. So first point is shit in, shit out, which means, you have a regulatory surrounding which you have to look at, and not really, it doesn't really matter on which side you are if you don't do your homework and don't think about your processing activities, your processes, your organization through in advance. You will be facing regulatory risk, either on the user side, but also on the vendor side, which might hinder business actually. So as it's a very strict regulatory framework we're talking about, it's better to have, let's say, an approach, as I said under bullet point 2, which is more on the design side than on the regulatory side. What I find, when I consult a lot of clients, is that actually privacy is always seen as a regulatory burden, but not as probably a opportunity when it comes to the design phase, and especially to the guys from legal techs and from the tech side. If you develop software, usually it's quite easy because you try to put everything, what you want to do or what the software shall do in the future into the design phase. And if you look at privacy and data protection and I would say cyber and IT security too, you should really look at this in the design phase too, because if you don't approach privacy and data protection proactively, it's usually a lot harder to cope with problems which you didn't actually look at in the beginning of a product or in your purchasing process. So this means actually, especially for legal tech companies, that failing to look at privacy issues in the design phase usually results in high expenditure and potential costs, and you know, might have not a problem, or it might occur a problem not only with regulatory issues, but especially when it comes to sales, if you're not compliant in these points, because we will see later on that, you know, not only privacy could pose a risk, but also regulatory requirements, which comes from, you know, regulatory frameworks from law. So it's always good to have a practical and proactive approach, although it's probably not so common. And last but not least, here, hands-on privacy work has little to do with legal. Why is that? Because I would say, from my experience, that privacy has a lot to do, as we see here, with project management, your own IT processes, privacy by design, privacy by default, which are more or less issues from, you know, the design phases and the processes you establish. And from that, you know, you can start to understand the regulatory requirements. So when you try to divide privacy from actually privacy law or data protection law, you will see that in my experience over the last 12 years or so, that, you know, the issues of project management, data protection management, building your own processes will be around 45% of the work you have to do. And if you don't have the facts and figures from, you know, your processes and your designs, it will be very hard to apply the law then. So understanding what you're doing and transparency on, you know, what you're doing with regard to personal data and, let's say, classified data is a very good starting point. And, you know, this is sometimes a thing where lawyers are not so good looking at. You know, I had recently a speech at, you know, the Cologne Lawyers Association, and when it comes to basic requirements such as records of processing activities and stuff like that, there were just like 20% of the lawyers attending had you know, such documentation. So I would say the smaller the law firm, the worse actually the privacy compliance. So let's start with the facts and figures, and from that you have, you know, the chance to get more and more compliant when it comes to regulatory requirements. So another simple truth over the last past years is data protection rarely comes alone, but with a lot of cross-references, such as the protection of professional secrecy, trade secrets, requirements with regard to IT security, cybersecurity. And if data breaches occur, it's even worse when it, you know, when you have to consider probably damages and potential costs in order to mitigate these breaches. So you have to be, in my point of view, quite open-minded to all fields which come together with data protection. And to cut it short, in my opinion, or in our opinion, you can only cope with data protection if you choose an integrated approach between legal, let's say, often it's change management, but you could say it's just like project and process management as well, and IT security. So you really have to have these three fields in mind. And it doesn't really matter if you are from the vendor side or if you're a user and use legal tech, or it doesn't really matter if, are more customer facing. Probably you can lack a little bit, the professional aspects of being a lawyer from that side. But it's really dependent on what you do and what your business case is. But generally speaking, this is very, very important. And don't forget change management, process management, and the IT security field, because if you don't have the facts, you cannot apply the law, which is usually a problem when it comes to um, safeguarding, let's say, your compliance efforts. I was just like thinking when I prepared that masterclass today, what is legal tech? So as I said, I come from a background in 2006, 2008, when nobody really used legal tech, and it was just like more or less a market of legal information, just like big databases such as LexisNexis or Wolters Kluwer, or in Germany, Back Online, as well as administrative tools in order to streamline processes in a law firm. So at that time, there was not a lot more to find when you were referring to legal tech, and the market really has changed in my point of view. So if I just like put on a brief description from Wikipedia, stating legal technology, also known as legal tech, refers to the use of technology and software to provide legal services and support the legal industry. I would say probably to disrupt the legal industry as well. So it's just like a different point of view and a different angle. If you try to attract consumers, or if you try to, let's say, do lead generation, or if you try to let's say, help law firms and lawyers getting more effective when it comes to their day-to-day work. So this is very, very broad, and we have very broad fields in which we can apply legal tech. So when we look at certain products or services, so we have kind of different approaches where we probably have lawyer facing or law firm legal department facing technology, such as right now AI tools, large language models, in order to help with contract drafting, for instance. We have a lot of consumer-facing technologies where providers try to enable consumers to get access to the legal market, such as flight ride. And in these cases, I would say you have different obstacles probably when it comes to privacy and data protection. And if we see at the newer tools, it's probably AI tools quite posh, or smart contracts, blockchain. And as I said, different business models lead to actually different privacy challenges, because probably, the regulations for lawyers are more strict than consumer-facing platforms. which, might have, an impact of the interplay between, let's say, typical privacy and data protection laws and the more regulatory rules you have to look at. And if we have a sharper look at what's really the difference between data protection and data protection law, then we would see data protection law is very focused on the law itself, but as I already mentioned, in my point of view, there's about 60% other things to do when it comes to process management and to IT security. And when it comes to data protection law, that refers really to all legal regulations relating to the processing of PII, personal identifiers, in order to protect the fundamental rights of a data subject. And just to have a look at German rules, there are tons of. So it's really a regulatory soup in which we're trying to navigate, or a regulatory sea in which we try to navigate us through, either as a law firm or a legal department or a legal tech provider. So in Europe, GDPR is all the same for us, but then we usually have regulations on the federal state side. In Germany, we have specific rules when it comes to telecommunications and websites and stuff. But we also have just like state laws and anything any regulation containing rules on retention periods and stuff are more or less relevant when it comes to data protection, because they determine your retention and deletion obligations. So we have a very, very broad setting which we have to look at, and that is a kind of burden when you try to tackle data protection. And when you look at this from a supplier's side, as a legal tech company, you should be pretty much aware of the legal framework your client is really operating in, because not only for regulatory reason, but in my experience, in order to accelerate your business. Good privacy procedures, good privacy and data protection documentation, should make your life a lot easier when it comes to marketing and sales. You read, most of the time that a tool is 100% GDPR compliant. If that is possible anyways, I would say there are always loopholes where somebody can just like put the finger in order to find something where you didn't stick to GDPR and local legislation, because it's just like a too broad legal framework you have to look at. But what I really have to say when it comes to, so we will come to some just like stuff when it comes to your documentation duties, such as records of processing activity or preparation of documents, when it comes to data privacy impact assessments and so on and so forth. Because the better you are in these fields, the better you can just like answer questions which might arise in discussions, especially when you have to sign DPAs and annexes to that, especially like technical measures which you have to fulfill. And it's very, very important, I think, that you have a basic concept how to tackle and how to approach that. And because if you look at what is data protection, it's much broader, because it's all measures relating to the protection of PII in the context of computerized, orderly, file-based processing of personal data. So data protection management is a very important point, and it works best if you're able to map your initiatives as a service provider to the initiatives and the requirements of your customers. So that makes onboarding a lot easier. And you can only, let's say, approach that, in my point of view, from process and project organizational measures and your overall accountability and documentation, such as I said, the ropers and data flows, and it's super important to have that, properly documented. Apart from that, you should surely look at technical data protection as well, especially when you're facing lawyers as customers or legal departments. And it's definitely something you should look at if you're customer in choosing your suppliers, because that is super important in order to have your own concept, in order to have a certain kind of literacy there, what are your requirements are in order to safeguard data or technical data protection, especially other things like business continuity, recovery concepts, in order to lawfully process personal data. And what I find is important too is, getting away a little bit from the legal point of view, but to see that data processing, no matter actually what kind of legal tech you want to use or you're supplying, that you think in data processing life cycles, because that's a good way to structure yourself, because everything usually starts with collection of data, and then you do something with the data. You're recording, you're structuring, you're probably organization, or you do the organization of data in order to then store data and to do actively something with the data, such as processing, alteration, adaptation of data. And if you don't look at just like globally, you probably lack a little bit of literacy when it comes to your own processes. And this usually leads to non-compliance, because your approach to your processes is too abstract in order to apply law against it and to apply especially technical organizational measures which suit your purpose there. So that is really important. And what usually is important too, or I named it the pillars of data protection, which is a life cycle or let's say areas of GDPR which you would have to look at in order to have just like preparations in place or processes in place. So it all starts with processing of PII, and you always have to ask yourself what is the legal basis to do that. We will come to the basic principles briefly later on, but there are so many things you really have to look at, such as data subjects rights, and there are most likely special rules on it when it comes to the work of an attorney at law, because it wouldn't make sense to inform the plaintiff of your planned proceedings, and usually you have attorney's privileges and stuff which you really have to look at and which you really have to be aware of when it comes to the processing. What is super important as well is data governance. So you should know how data flows through your IT processes. And then you have just like minor fee, or let's say minor fields. I would say privacy by design and by default setting is more on the legal tech side. Although, the data controller has to be aware of that too. DPO awareness, make sure that the business side is aware of data protection requirements, and you should always have a look if you have to appoint a DPO. And this is a little bit harsh because, especially in Germany, we have special rules on that because, if you have 20 person handling personal data, you're obliged to appoint a DPO in Germany, and you have to do that as well if you have to do a DPIA, which is sometimes forgotten in practice. And very, very important, data incident management, contract and supplier management, data transfers, data security, and risk management, especially when it comes to the DPIA. We come back to that later, especially in connection with AI tools. So the first resume, or first learning, sorry, I didn't translate the first sentence. Data protection, is a field of different areas. So bear in mind that data protection is not only data protection law, but a lot of organization of a company or a law firm, and it's a lot of technical safeguards and IT security. What you should bear in mind is as well is risk object is always the data subject and not your company. So when you or we discuss about data privacy, you should definitely adjust your risk appetite when it comes to data protection, because you would judge on risks for third parties, and then it's quite clear that you can't measure it as you would if it would be your own company's risk. And what really is the difficulty is the practical implementation in your organization. So my advice would be that you look at data privacy not only from a compliance point of view and from a regulatory point of view, but how data privacy can support your business case. And this is really the truth, I would say, for legal tech companies, or especially for legal tech companies, because the better you are in these regulatory fields, usually the better your business case is, and usually the better your or it should really accelerate your business in order to get deals through quicker and more easily. So take an approach where you try to use data protection as an accelerator for your business rather than just looking at regulatory steps. Probably just briefly, basics. What are the basic principles? So you will find them in Article 5 of GDPR. And it's the lawfulness of processing. So as I said before, there's no processing allowed without a legal basis. the processing has to be fair, it has to be transparent in a way. You have, the principle of purpose limitation. So you really have to define the purpose of for which reason you process personal data. And if you change purposes, this usually leads to the thought if you need a new legal basis to do so. And then you have data minimization. Only necessary data shall be processed. You have this principle of storage limitation. Data must be deleted if the legal basis, for instance, no longer applies. And then you have technical security, integrity, and confidentiality of data, which you have to safeguard as well. And all that, has to be proved because accountability applies here as well. So it's quite important to just like try to have that basic concept. So coming probably to the more, let's say, vivid part of the masterclass, I was just like thinking about some case studies or cases I support. So they streamline visas processes for foreigners, or that's their thought. And they have a lawyer in their team, and he addressed them, or he addressed to them that they should document their processes within ROPAs, which are the records of processing activity. Actually, this is quite interesting. Not the fact that you have to do that, but that nobody really tells you upfront how such a ROPA looks like and what you have to put in there. You have the basic framework in Article 30, but and there are so many templates out there from data protection authorities, from just like lawyers associations. And I've been doing that for 12 years now, and I did my first DPO course back in 2012. And when I just finished that course and I got my certificate, I went out to my client and was just like thinking, what is that ROPA really? What do I need that for? And how do I document such a processing activity? So from the idea, it's more or less a process repository for yourself. So it doesn't really matter if you are legal tech or a law firm, or plan to do digitization in these areas. It's always good to have a process repository. And first thing I would recommend is, you have to do that for regulatory reason in order to comply with GDPR requirements, but you should look beyond that. As I showed you, a good approach, because usually, these documents lack a lot of information, is to look at your business processes, IT process from this life cycle point of view, in order to have a more handy approach and more information on what you're really doing, because this really helps you to apply the law as well. So think of it rather than of a process repository than a compliance documentation, because you will find it quite easy to find safeguarding technical measures if you know what your process is really looking like. So I would always recommend to have kind of flow chart, what you're really doing, where the data flows, know where it comes from, where the data is flowing, and what the process is doing. That should really help you, apart from data protection, with other new technologies, because we're not really started with AI law yet. So a lot of things come really from data protection. So that is a really good approach in order to tackle this documentation and ROPAs. As I said, that also, most of the things you put into the ROPAs fall under general accountability measures, which you have to take. And look at documentation, what makes sense to have it in just like one file in order to be prepared, and to have knowledge for discussions and be able to hand out information if needed. So when it comes to that, think about approaching the documentation. Take your client's point of view, especially as a legal tech. You have an obligation to prepare a ROPAS for the services you provide. And usually, it makes life a lot easier when it comes to onboarding, when you can share that with your end user. And really approach it a little bit more from the IT side rather than from the legal side. So any kind of process diagram or life cycle data flows will definitely help you in order to get a better understanding what you're doing. And if you really understand what you do, you can change the processes or adapt to legal requirements, which will make life a lot of easier than before. And search for help. If you can't do the technical stuff on your own, just like grab the guys from the IT department or from the IT security department in order to help you there, and get better. So if we have a further look at data protection and professional secrecy, especially if you're providing services to law firms or to lawyers. First thing which is important is that you have to apply the GDPR from the one side, because it does not really recognize an exemption for lawyers. So it can generally be assumed that GDPR applies to lawyers, although the German Bar Association really would like to have their own supervision when it comes to data protection and lawyers, but there is none up to now. So basic rule apply. And just coming back to the situation in Germany, in the event of a conflict, however, the client confidentiality pursuant to the lawyers code in Germany takes precedence. So in order to have a compliant way of processing data, you really have to look at both. Apart from that, and I assume that in most other countries, there is a kind of criminal offense if you breach a professional secrecy as a lawyer. So bear that in mind, because that doesn't necessarily come from data protection and might have a broader scope than just PII in order to safeguard lawyers regulation as well as your legal tech business case. Apart from that, usually this regulatory lawyers codes have regulation on technical measures and safeguards as well. But what is important, usually it's quite parallel to what you would have to do when it comes to data protection as well, because it's just like referring usually to the measures you would have to take or which are appropriate under data protection. So you always should have a state-of-the-art IT security measures in place, no matter what, on which side you're standing. And with regard to lawyers, it's, we have some, in Germany, we have some crazy discussions from time to time, with regard to sending emails and encryption, if, transport encryption suffices, or if you have to use end-to-end descriptions. And if you look at, lawyers' statutory law, that is quite open. If a client wants me to correspond with him without encryption, that is fine under the regulatory or the statutory law. But what especially happens in Germany, because we have so many DPAs, so actually we have a DPA for every federal state. Apart from Bavaria, they have two. We have a federal data protection authority. So we have at least 18 different data protection authorities. And from time to time, there's just like one who takes a different view on certain issues. So you should be aware of that, as a lot of lawyers, if you have too many of them, you have just like too many different views on certain issues. And what you should bear in mind as well is if you choose an external service provider, or if you act as an external service provider, you're not only obliged to conclude a DPA with your client, but you should always have a look at the statutory law as well, if you have to provide certain different clauses in order to maintain confidentiality, or to fulfill these obligations of confidentiality. So always make sure that you stick to your regulatory scope. So when it comes to the usage of new tools such as legal tech, and this doesn't really come from data protection, you should look at it from a data protection point of view as well. Generally, for instance, in Germany, the lawyer may grant service providers access to facts to which the obligation of confidentiality pursuant to the specific laws applies, insofar as this is necessary for the utilization of the service. Service provider is another person, organization, blah, blah, blah. And you see the provisions of the protection of personal data, such as GDPR, remain unaffected. So just be aware of probably a broader scope than you would have to take care of when you're not acting in a regulated market. So, and from a practical point of view, I see we have just like 12 minutes left, but I don't know, I'm almost finished. Take care of your DPAs, so of your data protection agreements. This usually seems quite standard, but don't underestimate the complexity, especially if you use artificial intelligence, machine learning, or modern technology, because usually, it has to be kind of transparent what you do. If you have a client especially if you act as a legal tech, who's who has very strong compliance, or has strong compliance standards, because in that case you should be able to translate what you're doing into, let's say, understandable words. And what I put in there is do not use, or do not necessarily use, awkward clauses on anonymization and onward processing. It's something I've seen in the last couple of years a lot in software as a service DPAs. And if you do so, be aware of that. This is a processing activity, and how to cope with that. And you should have somebody at hand who's able to explain how your technical measures, such as pseudonymization and anonymization, works properly in order to safeguard um, data protection. And last but not least, you should always have a plan for your obligations to cooperate, which might be data breach or data access requests of data subjects right in special. You rarely see a plan between parties, or more specific annexes in such contracts, which just makes life a lot easier if you caught a ransomware attack or whatsoever. Because in that, if you have to think about what you should do in that scenario, it's usually too late. So you should have a good plan, and you should have a good understanding of both parties there, what are their requirements, and how such a escalation process should work. I just put in another, just like, case dilemma which I found in the press just 2 weeks ago, which is the DocuSign usage of user data to train AI models, and the problem, if the privacy promises are too vague or not. Actually, you probably have, in a legal tech environment, the problem that your provider wants to use data in order to do something else than providing you the service, which might lead to different problems, especially to the DPAs as well, because this could lead to a joint controllership, which you won't really like to have, especially if you're in that statutory world. So imagine this clause: if you have given contractual consent, we may use your data to train DocuSign's in-house proprietary AI models, which you probably wouldn't like so much as a law firm, or probably as a client of a law firm, really depending on, the information you're sharing with your software partner there, because, they definitely have a different purpose, and it's quite likely in our environment, if you don't really look at it prior to using a tool, that personal data is involved. So first way to do that is check the contracts, check if that is really your business case, or from the legal tech side, because if you look at that, and if you see, or if you take the approach as a legal tech, okay, I take the consent, I only do that with consent, I often have the feeling that the term consent is often used quite vague, because it's either probably a contractual obligation, and then you're just like have to look if that is transparent in itself, or if it's just like breaching what I mentioned before, that you have to safeguard the confidentiality of the information. That is probably a criminal offense if you don't have the consent of your client in order to provide data for training reason or whatsoever. So we will most likely come back to that in another masterclass later on the year. But you really have to be aware of the dilemma, either as a legal tech provider, but also as a user, because that could lead into not only a GDPR problem, but also into a regulatory or statutory law problem. And other dilemmas which might occur from that is risk. GDPR says extensive processing of data that is subject to social, professional, or special official secrecy, even it is not data pursuant to special data categories, and data on just like criminal offenses require a DPIA. According to the German authorities, that is part of their blacklist. So if you're using AI in order to just like do something like that, this might lead to the need to do such a risk assessment. And this is something which you only can do if you are really literate on both sides and know how technology works. So that's why you have to be quite open from a legal tech side. And when you look at it further on, it's just like an obligation under Article 35. So as a legal tech, you should, have a concept prepared that is, the best approach to tackle that, and to have a look at generally blacklisted processing activities, which can be, or in which AI especially can be evolved, or scoring algorithms, or things like that. So look at these risk categories, because legal tech is, especially when it comes to new technology, can be a trigger for such a DPIA, and you should both be prepared for that. Just skipping and coming for the last 3 minutes to cyber attacks and data protection. Just a few truths. Attacks on law firms, and I would say attacks against legal techs, will increase or have already increased in the recent years. And that's just like some German cases, but we had Alan Overy as well. And usually, ransomware is somehow a big topic, especially for law firms. And typical consequences are encryption. And be aware that you probably have new vectors in an AI environment, which can just like try to get bias into your data whatsoever. So be aware of that. And when it comes to ransomware, you just like have this typical problem of the encryption. And the crisis is not really the data protection, but the good thing is you can rehearse these scenarios. So you should, I strongly recommend you to do that. And you should work on a cyber incident policy and have just like proper technical measures in order to restore data for business continuity, and so on and so forth. So check your backup systems and look for data loss prevention. And because at the end, you just like have 3 options. First option is to pay money to the hackers. The other option is to decrypt your data, or you have a very strong backup system and you're very quick with recovering your data. I see, time is more or less over. we're happy to get your feedback via mail, as Marisa already said. That's my part of today. So thanks for your patience with me. If you have any questions, please refer it to Marisa and to ELTA. And if you need more input on these topics, we're really happy to get your feedback as well. And thanks for your attention, and have a lovely start into this week. At least here, it seems spring is coming.
Thank you very much, Guido. This was very interesting and very good to have. I look forward to many, many more sessions like this on other interesting topics. To everybody who joined us today, thank you very much. I do ask that you please direct all of your questions, requests for more information, anything along those lines, to the email addresses in chat. That is marisa.monteiro@elta.org. Please send us any questions which you may have. We'll happily get back to you, and then we will see how we reach out to establish a next webinar and how we can give you more value. Thank you very much. I'm going to stop the recording now. Enjoy the day. Bye-bye.